Hello everyone, welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, this is going to be yet another video about the state of New York, and I will tell you that we're doing a few too many videos about New York for a channel that's called Washington Gun Law, but I got to tell you, New York, you are terrible losers, and you are really poking the bear, that being the United States Supreme Court. See how far you can go. And I think we are kind of shaping up here for what could be a major showdown between the United States Supreme Court and the state of New York. So let's spend a few minutes and talk about it, because I think it's going to have some really, really important implications for a lot of these states that are thumbing their nose at this. So today, let's talk about who's going to blink first, New York or the Supreme Court? Okay, so the case we're talking about yet again today is Antonyuk v. Nigrelli. This is a challenge to New York's Concealed Carry Improvement Act, which was a response to New York Pistol and Rifle Association v. Bruen, which is a more terrible piece of legislation, absolute pile of crap legislation when it went into effect. We had a Judge Sotheby in the Northern District of New York, right here, very kind enough to author a 184-page opinion as to why every aspect of that law should be enjoined. We did a couple of videos on it, including this one here, where, hey, they actually found that, congratulations, New York, you wrote a law that violated 2 constitutional amendments. There's some real talent to that. Now, so New York, does they go back to the drawing board and start over again on drafting a new law? No, of course not. They go crying right away to the Second Circuit. Now, we have a judge who enjoined the law with a 184-page opinion. What does the Second Circuit do? In a 1-page order, basically lifts that injunction and says, no, New York gets to implement that law. Now, that, of course, kind of ticked off the United States Supreme Court. We did a video about that right here, and the Supreme Court told New York, hey, you know what? By January 3rd, you got to provide us with a memorandum of authorities as to why we shouldn't overturn what the Second Circuit did and let the injunction remain in place. Well, Attorney General Letitia James of the great state of New York has filed that memorandum of authorities. We're going to go through it a little bit today because I think it tells us a little bit more about what the agenda is here. It really is going to give us a roadmap of how those in the gun control community are essentially going to try to wipe their rear ends with the Bruen opinion. And then I do want to give it up to Miss James, because she actually does come out and say some of the things that we oftentimes complain about. And those in the gun-grabbing left say, no, that's all conspiracy theory, until, of course, they actually come out and admit to it. So that's what we're going to be talking about today, because I do believe that with the fact that the Supreme Court is showing great disdain for what's going on here, and then you read the tone of this memorandum, I think we are heading for a real old-fashioned fist fight here between the United States Supreme Court and the state of New York. Now, one of the big arguments that the state of New York makes, and every state makes this argument, is standing. And we've already done this video right here about what standing is. And while we can get into all the legal mumbo jumbo and the technicality, here's how you look at it strategically. Standing is an argument that you make when you don't want the court to decide the case on the merits. You see, if there's a standing issue, just like if there's a jurisdictional issue, if there's a venue issue, there's a summary judgment or some other kind of preliminary issue, that is always what the defense is going to argue. Because if you prevail on that, that's the end of it. We're done, okay? So when you see these standing arguments, and albeit there are a handful of them that actually have merit, but most of them are just designed to get a judge who does not have the courage to deal with these issues and does not have the courage to correctly apply the law, an opportunity just to get rid of the case, to jettison it based on standing. So a large majority of Ms. James' brief here deals with just the standing issue, because they don't really want to talk about the case on the merits itself. Now, on a few instances, they are kind of forced to talk about that, and it's what they have to say about that that should raise everybody's eyebrows. First of all, albeit that we all believe that the Bruen opinion is crystal clear, well drafted by Justice Thomas, the state of New York appears to still be in a state of confusion. According to the New York Attorney General, they see Bruen this way. In other words, Bruen decided nothing about who may lawfully possess a firearm or the requirements that must be met to buy a gun nor did it disavow previously recognized restrictions that may be imposed on the possession or carrying of guns. So the state of New York believes that the issue as to who is entitled to a firearm is still subject to debate. But the big reason for why they don't want to stay, why they want this law to be implemented and then just take the natural course of action, well, we know what the real reason is they write these laws that they know to be unlawful, they know to be unconstitutional, but they know it's going to take multiple years to work through the appellate system, and in the meantime, they can wear down and inflict their pain and misery on the people that they are trying to inflict it upon. That, of course, is the lawful and responsible gun owners. Not the ones contributing to the violence problem, not the ones contributing to the crime problem, not the ones contributing to the gun violence problem, but no, you folks, the lawful and responsible gun owners. And at least Miss James comes out and says that's exactly what they're trying to do, because here's how she put it. Bruen was also clear that the application of the restated Second Amendment standard would require substantial development in the lower courts in accordance with traditional patterns of constitutional litigation. For example, the court declined to undertake an exhaustive historical analysis of the full scope of the Second Amendment. Two fallacies with that argument. We'll start at the back end. Number one, that long, extensive historical analysis of the Second Amendment was not done in Bruen because it was done in District of Columbia v. Heller by Justice Scalia. Anyone who's ever read that opinion knows it's all in there. Second of all, Ms. James, the Bruen opinion did not restate the Second Amendment. The Bruen opinion clarified what all of us previously knew about the Second Amendment. Many of you had become confused about it, and the Bruen case merely provides crystal clarity for all of us. But we need to wait and let it kind of work itself out. And this is how else Ms. James put it in this brief. In addition, this case involves the application of Bruen, which was issued only 6 months ago and which revised the relevant constitutional framework for Second Amendment challenges. This ordinarily awaits percolation of legal issues in the lower courts before granting review and would benefit from such percolation here. Now, you'll notice that there is no legal authority cited to that, but let's take that logic and use it the other way around. So Miss James is arguing that, hey, because this case is so new, we really should let it kind of ricochet around in the lower courts, let some states kind of trample all over it, and let's see what this really, really means. Well, using that logic the other way around, how did that work in Brown versus Board of Education when there were governors who absolutely positively did not want to obey a pretty clear rule of law? How would that have worked after the announcements of the Supreme Court ruling in Obergefell v. Hodges? Oh, what case is that? Oh, that's the case that ruled that homosexual couples have a constitutional right to be married. Wouldn't that have been interesting if someone would have said, well, you know what, that's a pretty new standard. We probably ought to let that percolate around in the lower courts for a bit, let some states kind of trample on it a little bit before we kind of figure out what that really means. What if they would have had that position after the National Federation of Businesses versus Sibelius? What case is that, you say? Well, that's the case that actually ruled that the large portions of the Affordable Care Act, or what's called Obamacare, were in fact constitutional. Can you imagine if there would have been a bunch of states saying, well, you know what, I know that the rule of law was announced there, but we really kind of need to let that percolate around in the lower courts, let some states kind of mess around with it, and let's see what that really means. Hey, can you imagine when Roe v. Wade was published back in the 1970s if states would have said, well, we understand what it says, but in fact, let's let that percolate around. This is a standard that apparently only applies to Second Amendment cases, not to any other cases with similar constitutional magnitude, at least according to Miss James' office. And one of the final reasons that Miss James gives for why this law needs to be implemented and therefore the injunction lifted is that, well, they just don't have enough time to properly prepare for this. And really what we ought to do is err on the side of caution, which is let the law be implemented because, the state never ever realized that there might be these types of challenges. This is how she wrote it in her brief. Third, a stay is necessary here because the district court enjoined enforcement of a duly enacted law without giving respondents a meaningful opportunity to mount a defense. Indeed, the court gave the appellants less than 3 weeks in total to oppose both a TRO and a preliminary injunction. But yes, I will remind you, Ms. James, that Governor Hochul called an emergency session 3 days after the Bruen opinion was announced and had this legislation passed in 8 days. For anyone in the state of New York to suggest that the state of New York needs more time when you gave the citizens of New York absolutely no time to prepare for this new oppressive law is not only disingenuous, but it defies common sense. And Ms. James concludes that the court would likely have no interest in taking this case, and even if they did, the plaintiffs would have literally no chance of prevailing whatsoever, so it's really just not that big of a deal, just let it go. And that is essentially the tone of this memorandum. Now, we already know that this was at the bequest of the United States Supreme Court. Now, we know that Justice Sotomayor is going to be reviewing that, and she has sole discretion to decide whether or not to reverse the Second Circuit. However, and let's remember this is part of the Supreme Court rules, if Justice Sotomayor chooses to uphold the Second Circuit, the petitioners in this matter, which is Mr. Antonyuk and the Gun Owners of America and all that, they could actually refile that petition with any other justice in the United States Supreme Court. I can think of at least one justice that might be interested in hearing it. The bottom line is I believe that the state of New York and the United States Supreme Court is heading for a showdown, and it's going to be interesting to see who blinks first. In the meantime, if you have any questions about this or anything else related to your Second Amendment rights, you guys know the drill. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.